Friends, today we shall discuss the right to freedom of religion, which is guaranteed under Articles 25 to 28 of the Constitution of India. To start with, the Preamble to the Constitution of India declared that the people of India have solemnly resolved to constitute India into a sovereign democratic republic to ensure, amongst others, the liberty of belief, faith and worship. This means that people should observe an attitude of neutrality or impartiality towards all religions. In this sense, India under the Constitution is a secular state, although the term secular is not mentioned in the Constitution before the 42nd Amendment 1976. The 42nd Amendment has inserted the term secular in the preamble, even though without insertion of the term, India stands for a secular state from the very beginning due to the expression of the term liberty of belief, faith and worship in the preamble. Consequently, the state has no official religion. The Constitution has given full opportunity to all persons to practice, profess and propagate a religion of one's own choice. It not only ensures freedom of religion and conscience, but also ensures the freedom of one who has no religion and restrains the state from making any discrimination on the ground of religion. Articles 25 to 28 confer rights relating to freedom of religion not only to citizens but also to all people in India. The provisions taken together is a guarantee of religious freedoms not only to individuals but also to religious groups. It will not be out of place to point out the international law on the subject of freedom of religion. Article 18 of the International Covenant on Civil and Political Rights 1966 refers the freedom of religion to mean freedom of every man to adopt a religion of his choice. Further, no one shall be subjected to coercion which would impair his freedom to have or adopt a religion or belief of his choice. Article 25 of the Constitution guarantees to every person the freedom of conscience and the right to freely profess, practice and propagate a religion. This freedom is subject to public order, health, morality and other provisions relating to fundamental rights. Further, the state is not prevented from making any law to regulate or restrict any economic, financial, political or other secular activity which may be associated with religious practice, or any law providing for social welfare and reform or throwing open of Hindu religious institutions of a public character to all classes and sections of Hindus. Therefore, it becomes imperative to clearly understand the term religion. The dictionary gives the meaning of the term as a belief in the existence of a god or gods, especially the belief that they created the universe and gave human beings a spiritual nature which continues to exist even after the death of the human body. However, the term religion is not defined in the Constitution. The Supreme Court had the opportunity to explain the term religion in an expansive content in Commissioner of Hindu Religious Endowments versus Lakshmindra Swamiyar, which is reported in AIR 1954, Supreme Court, page number 282. The fundamental right to freedom of religion guaranteed to every person is not merely to entertain such religious beliefs as are allowed to him by his decision or conscience, but also to exhibit his beliefs and ideas in such overt and outward acts and practices as are sanctioned or enjoined by his religion. Religion is a matter of faith. A religion not only lays down a code of ethical rules for the followers to accept, but they may also prescribe rituals and observances, ceremonies and mode of worship which are regarded as an integral part of the religion. These may cover not only doctrines or beliefs, but also covers the matter of food as well as dress. Thus, the constitutional guarantee of freedom of religion contained in Article 25, Clause 1 extends even to rites and ceremonies associated with a religion. But in order to treat practice as a part of religion, it is necessary that the practice should be regarded as the integral part and essential part by the said religion. It is interesting to note that the courts have examined religious scriptures to ascertain as to whether a practice in question is an essential part of the religion or not. To cite such an interesting question that arose in the case before the Supreme Court of India is M.S. Qureshi versus State of Bihar, which is reported in AIR 1958, Supreme Court, page number 731. The question raised in the case was to whether or not the sacrifice of cows on the Bakar Eid day by the Muslims is an essential religious right as enjoined by their religion, that it needs to be protected on the touchstone of freedom of religion, which is guaranteed under Article 25 of the Constitution. The Supreme Court had gone into religious texts of the Muslims and also considered the interpretations of the learned persons of Muslim religion on the question. The court found that as per their religious texts, cow sacrifice for a Muslim on the Bakar Eid day is not an overt obligatory act for a Muslim to exhibit his religious belief. Under Article 25, Clause 2a, the state is empowered to regulate secular activities associated with religious practices. The distinction between religious and secular is important to ascertain as to what is religious cannot be regulated. The activities which are economic, commercial or political in their character, even though associated with religious practices, can be regulated. Under Article 25, Clause 2b, the measures of the social reform are permissible and would not be void on the ground of interfering with the freedom of religion. Article 25, therefore, involves a separation between religious activities on one hand and secular and social activities on the other. The Constitution not only guarantees the freedom of individuals to profess, practice and propagate his religion, there is also the right guaranteed to every religious groups or denominations under Article 26, which lays down that, subject to public order, morality and health, every religious denomination or sections of it has the right, first, to establish and maintain institutions for religious and charitable purposes. Secondly, to manage its own affairs in the matters of religion. Thirdly, to own and acquire movable and immovable property. And fourthly, to administer such property in accordance with law. Article 26 guarantees collective freedom of religion. The term religious denomination in the Article 26 will mean a religious sect having a common faith and organization and design by a distinct name, having indicated by the decisions of the courts. Some religious denominations are worth mentioning, that is, the followers of Madhavacharya, the Shwetambar sect of Jains, the followers of Zoroastrian religion, the Gauda Saraswat Brahmins, the Daud Bohras may be mentioned to constitute religious denominations. The words establish and maintain occurring in Article 26 suggest that when an institution has been established by a religious denomination, it can claim a right to maintain the same. The right to maintain an institution includes the right to administer as well. Therefore, a denomination has no right to maintain an institution which has not been established by it. In a case before the Supreme Court, Aziz Basha versus Union of India, reported in AIR 1968, Supreme Court, page number 662. The question for determination was as to whether or not the Aligarh Muslim University, which started as a school and later on a college and ultimately became a university, is a minority institution reserving the right to administer the same by the Muslim community. The court held that a university is established by a statute and not by the Muslims, and as such they cannot claim the right to administer and to maintain the same. Which is laid down in Article 27 of the Constitution. It is provided that no person shall be compelled to pay any taxes, the proceeds of which are specially appropriated in payment of expenses for the promotion and maintenance of any particular religion or religious denomination. This article is the necessary consequences of secularism. A tax is a compulsory exaction of money for public purpose. If the state exacts money through a tax whose proceeds are assigned for the benefit of a particular religion, then obviously the state patronizes that religion. Hence, there is prohibition against those taxes. But the distinction between a tax and a fee is relevant here, as it is a tax that cannot be levied by the state under this article. The state can charge fees for secular regulation, for defraying expenses of administrative regulation. Thus, a fee can be levied on pilgrims to a religious fair to meet expenses of the measures taken to safeguard the health, safety and welfare of the pilgrims. Under Article 28, no religious education is to be imparted in any educational institution which is wholly maintained out of the state fund. This restriction would not apply to an educational institution which, though administered by the state, but has been established under an endowment or trust requiring that religious instruction should be imparted in such an institution. Under Article 28, Clause 3, no person attending an educational institution recognized by the state or receiving aid from the state funds can be required to participate in any religious instruction imparted in the institution, or to attend any religious worship conducted in the institution, or any premises attached thereto, unless he consents to do so voluntarily, or if in a minor his guardian gives his consent for the same. The Constitution of India stands for a secular state. It gives full opportunity to all persons to profess, practice and propagate religion of their choice. Dr. Radhakrishnan, former President of India, in his book Recovery of Faith, explained secularism of India as follows. When India is said to be a secular state, it does not mean that we reject the reality of an unseen spirit or relevance of religion to life, or that we exalt irreligion. It does not mean that secularism itself becomes a positive religion, or that the state assumes divine prerogatives. We hold that no religion should be given preferential status. The view of religious impartiality or comprehension and forbearance has a prophetic role to play within the national and international life. So a combined summary of Article 25 to 28 and a preamble to the Constitution of the expressions republic and qualified by another expression of secular would stand a witness that India is a republic in which there is equal respect for all the religions. But of course, the right to freedom of religion is subject to public order, health, morality and other provisions of the Constitution. So friends, thank you very much.